The Economic Crime Act was fast-tracked as a result of the situation in Ukraine. Chris, as a member of our global compliance and investigations team, can you just talk me through what that entails?
The Economic Crime Act is actually a bit of a hodgepodge. It does lots of different things. It doesn't have one overarching theme. It's almost as if when the invasion of Ukraine happened, the UK government thought something needs to be done, this is something, let's get it done. And there are a lot of items in there that clearly had already been prepared that just hadn't been introduced into legislation yet.
Okay, and looking at the Act in more detail, what sort of provisions does it actually include?
So it deals with three key issues. First of all, it introduces a register of overseas entities. Second, it strengthens the unexplained wealth orders regime. And third, it strengthens the sanctions regime.
Can you explain a little bit further this proposed register of overseas entities?
Sure. This is the area that's grabbed the most attention. So Companies House will have a new register of overseas entities, and that is quite simply a list of entities that are governed by the laws of a territory or country other than the UK. If you're an overseas entity, then you'll need to register in order to purchase property. You'll also need to register if you have already purchased property in the UK. And as you'll have gathered from that, this Act therefore has retrospective effect. If you're an overseas entity that purchased land or property in England and Wales after the 1st of January 1999, then from the moment that the register goes live, you'll have 6 months to provide the necessary information to Companies House. Now, that information will include details about the beneficial owner of the overseas entity. And that will include the owners or entities that have 25% or more of the voting rights or 25% or more of the shares in the overseas entity, or an individual or another entity that exercises significant influence or control over the entity that needs to be entered onto the register. So that is quite a significant development, and a lot of companies that currently operate in the UK will have to be extremely mindful of this and of the administrative requirements that are involved in that.
Okay, and then what happens if somebody submits information that's maybe false or possibly misleading?
So if the information is false or misleading, then the individual that submits it can be subject to a fine. If the individual submits false or misleading information and they know that it is false or misleading, then they can be subject to a fine and imprisonment, potentially for a term of up to 2 years.
I understand that this information has to be updated annually. If I'm right in that, what happens if someone fails to do it?
You are right in that. It does have to be updated annually. If the information isn't updated annually, then the entity commits an offence, but also every officer of the entity commits an offence as well. And both entity and every officer will be subject to a fine, but also they'll be subject to a daily fine for each day that they fail to submit the relevant information to Companies House.
Okay, that's interesting.
There's one more point I just wanted to make there about offences generally, and because obviously this new Act imposes further obligations on Companies House particularly, but also the Land Registry as well. And the important point here is enforcement. Offences are only as effective as how well they are enforced. Companies House, and perhaps to a lesser extent here the Land Registry, are going to have to be funded properly so that they can take on board all this new information, that they can verify it, and that they can enforce all these fines that we're talking about here.
Chris, you mentioned earlier unexplained wealth order regime. Can you just talk us through that a little bit further, please?
Yes, so unexplained wealth orders, or UWOs, are an investigative tool for UK government agencies. In certain circumstances, they can apply to court to require an individual to demonstrate that they purchased property in the UK by essentially legitimate means. And this Act strengthens that regime. For example, in order to avoid evasion of the UWO regime by hiding behind complex corporate structures, where a property is held by a corporate or another legal entity, then now the agency can designate a specific individual, a responsible officer, on whom that UWO can then be served.
And what are the risks for the UK enforcement agencies in applying for one of these UWOs?
Yeah, so UWOs, although they were greeted with much fanfare, they've actually been used sparingly. And the difficulty has been that the agency that applies for one can be on the hook for the costs of the person who's on the receiving end of the order if the order is appealed and that person is successful in their appeal. And there's been one case where the UWO was appealed, was overturned, and the agency that had sought the UWO in the first place was liable for costs of £1.5 million. And that's the usual situation in civil litigation in England and Wales, because importantly here, the UWOs are civil litigation tools rather than criminal litigation tools.
And I guess that's quite a deterrent. So what does the Act do to try and eliminate that risk?
So the Act now, helpfully from a government agency perspective, essentially all but eliminates that risk by saying that courts can now no longer give costs orders against the agency that applies for a UWO, except in extremely limited circumstances. And those include where the agency was dishonest, which, as you can imagine, is an incredibly high bar.
And what does the Act do in relation to sanctions, Chris?
So, as I said, the Act strengthens the sanctions regime. It makes it easier, it makes it more straightforward to designate individuals or entities to be subject to the UK sanctions regime, and it introduces an urgent procedure for that to happen. In fact, as soon as these powers were introduced, when the Economic Crime Act became law, the UK government immediately used those powers and sanctioned 370 Russian and Belarusian individuals in one go.
Interesting. Just to close, Chris, from your perspective, as a member of our global compliance and investigations team, what would you say the key takeaways are on this topic for our clients?
So the kind of fairly obvious key takeaway for any business that wants to operate in the UK is this register of overseas entities, and making sure that once that register is live, that you are complying with it, both providing the required information when the register goes live and maintaining that information on the annual basis as we previously discussed. But actually, an important takeaway is that there's more to come. A second Economic Crime Act has been promised in the next session of Parliament, which starts during May. And as a result, that second Economic Crime Act may well contain potential offences that have been asked for quite some time by prosecutors and law enforcement in the UK, particularly the introduction of a failure to prevent economic crime offence, which would have wide-ranging implications for any business that would be operating in the UK. So we need to keep an eye out for that, what's coming down the track.